Good afternoon, everyone. Welcome to today's capacity building webinar on developing Amicus Curiae brief for the African Court's advisory opinion on climate change. We apologize for the delay in getting started. One of our speakers have had some technical difficulties, so we just wanted to allow him the time to get everything together to join. My name is Angela van der Berg. I'm a professor at the University of the Western Cape and the director of the Global Environmental Law Centre, and it really is a great pleasure to host and facilitate today's discussion. This event is co-organized by the Global Environmental Law Centre, Natural Justice, the University of Southampton, the Environmental Lawyers Collective for Africa, and the African Climate Platform. Today, these partners are working to ensure that the upcoming advisory opinion before the African Court on Human and People's Rights becomes truly inclusive, well-informed, and a transformative process for the continent. As many of you will know, the Pan-African Lawyers Union, PALU, in collaboration with several African civil society organizations, has submitted a request to the African Court on Human and People's Rights for an advisory opinion on the obligations for African states as it relates to the climate change crisis. This is a historic first for Africa and potentially a defining moment for the continent's climate justice landscape. For the first time, an African regional court is going to be asked to interpret the African Charter and related human rights instruments in light of the climate emergency. The advisory opinion could provide much needed legal clarity on what African states must do within the human rights obligations to prevent harm, protect vulnerable communities, and pursue development in a manner that is fair, just, and sustainable. The request before the court centers around three interrelated questions, which I can summarize in brief. The first question asks the court to clarify the scope of African states' obligations under the African Charter and other instruments to prevent, mitigate, and respond to climate change and its impacts. This includes how these duties relate to rights such as life, health, development, and the right to a satisfactory environment. The second question focuses on how states should safeguard the rights of groups most affected by climate change, including women, children, the elderly, Indigenous people, and environmental human rights defenders. It highlights that climate impacts in Africa are not only environmental or economic, but deeply connected to equality, participation, and dignity. The other question, there are sub-questions, but the other question relates to states' human rights obligations to ensure a transition to a low carbon and climate resilient future. So this is about the just transition, making sure that states take measures to decarbonize economies and not to reproduce social and economic injustice. So these questions lie at the very heart of Africa's contribution to global climate justice, seeking to define what is a fair, rights-based, and inclusive climate response on our continent. The purpose of today's webinar, is to equip academics, practitioners, and civil society organizations with the knowledge and tools to engage with this process by submitting amicus curiae briefs to the court. We're going to explore procedural, substantive requirements for amicus submissions, lessons from those who have already participated in regional human rights litigation, and strategies for ensuring that submissions complement rather than duplicate one another, hopefully building on a strong, coherent African legal voice. We are really fortunate to be joined today by three speakers whose expertise span human rights, environmental law, and regional litigation. Just before I introduce the speakers, are all the speakers present?
Yeah, they are.
Excellent. Okay. So I am so happy to introduce to you our first speaker of the day, who is Mr. Zimbabwe Chimga. He's the technical leader at the African Climate Platform. Z is an award-winning international human rights lawyer with over 2 decades of experience in democracy, governance, international law, and climate justice. He has led human rights protection initiatives at domestic, regional, and international levels, including litigating before the African Commission and the African Court on Human and People's Rights. He holds law degrees from the University of Zimbabwe and Notre Dame University in the United States. And today, Zee will provide a step-by-step procedural guide on how to prepare and submit amicus briefs before the African Court, including timelines, formatting, and strategic considerations for effective engagement. Our second speaker is going to be Mr. Brian Kibirangu. He is the manager of the Litigation and Implementation Unit at the Center for Human Rights at the University of Pretoria. He leads the Center's strategic engagement with African human rights mechanisms, where the Center has a strong record of appearing and intervening before African Court as Amicus Curiae. He coordinates advocacy on implementation of African human rights decisions and the ratification of key regional treaties. He is also a doctoral researcher at the Center, focusing on the effectiveness of international and regional human rights framework. He will share insights today on strategic framing, institutional credibility, and coordination among actors, all crucial for impactful amicus briefs. Finally, we then are going to hear from Mr. Lucien Limaker, the head of programs at Natural Justice. He is an environmental lawyer, mediator, and long-standing advocate for community lawyering and participatory justice. He leads multiple work streams and oversees programs across the continent, ensuring strategic alignment and innovation in advancing environmental and social justice. He holds an LLB and LLM for the University of Witwatersrand. And today he is going to focus on reflect on how amicus submissions can strengthen broader narratives for African climate justice and offer strategies for collaboration, follow-up advocacy, and long-term impact beyond the court's eventual opinion. Before we start, I think we have a little bit of housekeeping announcements. The first being that this webinar is being recorded. We are going to edit the recording slightly just to streamline it, and then the recording will be made available on the University of the Western Cape's YouTube channel. I will also share the recording with our partners today, and they will very likely make it available through their platforms. You're welcome to post your questions or comments in the chat box or Q&A box, and we are going to address questions at the end of the session after all the speakers have spoken. And then just finally, if you could keep your microphones muted throughout to minimize any background noise. Without further ado, though, it is my great pleasure to welcome our first speaker, Mr. Zee Chimba, who is going to speak to us on how to prepare and submit these briefs to the African Court. Thank you, Zee. I hope you are you going to present a presentation, or you're just going to speak?
Hi, Angela. Thanks so much. I hope I'm clear. You can hear me. Confirm, Angela.
We can, yes.
All right, thanks. Yes, I think there should be a share option. If somebody can enable me to share, I think I'll need somebody to just enable me to share. I'm sitting in Joburg. I just lost power at 12, so I had to dash to use my Wi-Fi from the vehicle. So much for Africa for you. But thank you so much, Angela. Whilst I'm just, I'll try now. I think I can share now. Let's see. Right. Okay, it seems to be giving me a fault message. Okay, you know what? Whilst I'm trying to do that, I think I'll just get on with it. I can just speak from my presentation, but if it then shares at some point, that's still fine. So thank you.
To email
Is that okay?
If you want to email your
So,
presentation
okay.
to me, then I can
can.
share it.
Yes, you can email it to any one of us, and
can.
we can move the slides forward for you if you like.
Okay. Okay, maybe I can send to Norma. Is that okay? I think she's on the
Yes.
call.
That's perfect.
All right. Okay, thank you. I'm doing that right away. I think I've sent to Norma. Should be okay.
I think you didn't attach it.
I noticed and then I sent the second one. It should be
Or did
on
you
its
send it?
way.
Okay, the second one should be on its way then.
Yes, yes. We should get this.
It still hasn't come through. I can see the first one, but for some reason the second one.
I think it's because it's a bit heavy with the slides, but it should be on its way. Anytime.
Okay, I think I see it. Perfect.
But maybe you can just tell us it's coming. All right. Okay. All right, Shens, and as introduced by Angela, I will be talking about how to submit observations to the African court, trying to give a step-by-step guide for the participants that wish to make submissions to the African court. And I deliberately use the word submissions because you'll notice I'll talk that in the rules, they make reference to observations. So I'll deliberately use the word observations. But whenever we talk about observations, we're actually talking about the amicus briefs. You do not find the word amicus briefs in the protocol establishing the court or in the rules sections. So we talk of observations, but in essence, we are talking about the same things, whether you're talking about observations or you're talking about the amicus briefs, it's essentially one and the same thing. So just to get us started, let me make the point that the process of amicus briefs are four sources of law that we need to look at when we talk about advisory opinions. And obviously, we've got the protocol to the African Charter on Women and People's Rights on the establishment of the African Court, which is the one that provides for advisory opinions. Then we've got the rules of procedure of the court that I've already spoken about. And the court has since come up with what they call practice directions. They've got the power to do that in terms of Rule 28 of the court. So they do have practice directions of 2020-24 that, among other things, also speak to amicus briefs or observations, as I've said. And the final point and source of law is previous advisory opinions that have also dealt with amicus briefs. So whenever we speak about the amicus briefs and how they should be presented before the African court, we tend to zero in on those four. So Just to get us started, and I think most of you that have interacted with regional mechanism, and in particular the African Court, I think we're quite that the African Court on Human and People's Rights is established by the protocol. It's quite a word title, the protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights. So every time I'm talking about the protocol, I'm talking about that. And in terms of advisor opinions, the court itself deals with both contentious cases and advisor opinion cases. And obviously, because of what we're doing on advisor opinions. And we know in terms of Article 4 of the protocol that number one, member states of the AU can request advisor opinion.
Sorry,
The
can we please
AU
move the
itself
slides?
can request. Oh, okay.
Sorry, Z, what's happening is the slides are not actually showing up
Okay,
as an interview
right.
to us, and we're not moving away from your cover slide. And so all this valuable information you're giving us, we're not able to actually read. I think Noma Sangu is sharing. If you could please maybe fix that. Thank you.
Okay. Sorry about that. Am I able to control, or she has to send? Because I'm just trying to see.
Noma, you'll need to move them along.
Yes. Is that okay? Is she able to
So I'm
move
able to move them
on?
along just as long as you let me know when to
Then I
move on
can
to the next
just
one.
say next, and we can.
Yes, that would be perfect.
We are on. Okay, perfect. So I think just in my apologies, I hadn't noticed that. So let's just go back to it will be slide 3. I think we're further down. If we can just go back up to the 3rd slide. I think it's taking a bit of time, right?
No, Z, we are on slide 3. You can proceed.
Right, yes. Okay. Okay, perfect. All right, perfect. So just quickly, so I was making the point that the court has got jurisdictional power to deal with advisory opinions that are submitted to it by those 5 that you are seeing on the screen. AU member states, the AU itself, organs of the AU, and any African organization that is recognized by the AU. So those 4 can request for an advisory opinion from the court. And what is important to note that its jurisdiction in terms of who, then in terms of what the court to the charter, and when we talk about the charter, we're talking about the African Charter on Human People's Rights or any other relevant human rights instruments. So we can move to the next slide, Norma. So in terms of the our conversation today, we'll limit ourselves to advisory opinion has been filed, and I think that's what most important, what most people are interested in, is the process by which then other parties can join by the court. And in order for you to do that, we then have to go by the process of what I've called the observations, or if you like, amicus brief, as we tend to say in international law and domestic law. So you can move to the next slide, Norma. I think it's taking a bit of time.
It is on slide 4 now, or no?
All
Norma,
right.
are you able to move it?
Okay, so on my screen, I'm still on 3. Yeah, it looks like there's a lag.
Just letting you know, the viewers also see slide 3. We are now on slide 5. It's just moved to slide 5.
I think
Sorry,
there
I
might
think
be a delay.
yeah, there might be a delay, possibly. What slides can you see right now? Slide 5?
Slide 5,
And what slide do you need to be on?
4.
Okay.
It's going to 5. It's just the one before that, which is 4. Yes. Right, perfect. So I remember speaking about, I talked about the protocol, which is the one that talks about advisor opinion, but the protocol itself does not make reference to the process of amicus. And for that, we have to go to the rules of court. The latest updated rules of the court are the 2020 rules of court. And in terms of Rule 83, sub Rule 2, the way the process happens is that the court tries a request for an opinion on court's website, and then they transmit copies of that request to specific parties. That's the first side of observations. The court on its own accord, or Romero motu, as we like to say as lawyers. And the court has got a standard procedure where it invites observations from firstly member states of the AU, the commission here is the African Commission on Human and People's Rights, and specific AU organs, as well as any other relevant entities that it deems necessary to invite to make submissions. So this is the straightforward and direct route to submission of amicus briefs. If the court invites you, it means that you don't have to make an application. And it always gives that opportunity to states and members of the AU. But we've seen with the cases that have come before the court dealing with advisor opinion, that the court also identifies particular organizations to make submissions because of the thematic knowledge that they bring on board. So just I drew some of the organizations that were invited. If we go to slide 5, Norma, you will note, I think Angela has already spoken about the case that we've brought via Palu before the African court dealing with the climate. In this particular case, we know that on 4th September 2025, which is just a month ago, the court invited a number of entities to make submissions of amicus. And those 8 that you are seeing on the screen are either AU organs or their states and other AU organs. So you've got the AU, you've got the AU Commission, you've got the African Commission on Men and People's Rights, you've got ECOSOC, PAP, African Committee on Experts on the Rights and Welfare of the Child, the Director, AU Gender Director, African Union Commission. So those are the either intergovernmental entities or states themselves that have been invited. However, next slide. The court has also proceeded to invite, in accordance with Rule 83, specific organizations that bring on board thematic expertise, and I've listed all of them. There are 11. One of the things that's quite interesting is that they also invite either organizations and entities, but I notice in some respects they even invite individuals that bring thematic expertise on the issue before them. And for the purposes of time, but you can see there are NGOs, there are academic institutions, and there are some eminent jurists that have been invited. And of course, we've got your network of national human rights institutions. So these ones get the first bite of the cherry in the sense that they are already in. And the court, in accordance with Rule 84, has invited these parties to submit observations or amicus briefs within 90 days. We can move to the next slide, Norma. And we know that the court counts these as calendar dates. We hear a lot of people asking in terms of how are these dates counted. So it's in terms of calendar dates. So if you want to work from 4 September, it should take us to 3 December. And these entities are requested to submit within that period. But I'll spend more time talking about other parties, and I think that is where most of the people that are on the call are interested in. And we know that in terms of Rule 83, Sub-Rule 2, the court also can allow other parties to make submissions. Our next slide. And based on the rules themselves, do not expand on the process and how this is done, which were recently adopted in 2024. And of course, prior precedents in other cases, that this has to be done via an application. So a party, and this is the important part, a party that seeks to make submissions or observations that we call amicus briefs has to make an application. And one of the key questions that keeps coming up is, does the court require you to make an application first for leave? And once you get that authority to submit, you then submit the substantive arguments, or you should make the application for leave together with the substantive amicus brief submissions. And I think the answer, based on my research and experience with the court, is either of the two have been used. If you look at the practice directions that I've spoken about, and I'll go into them in a moment, the 2024 rules, they seem to suggest that you have to make an application first. And of course, within the application, you must express an interest in the case and what it is you want to bring via the court. And once you've done that, then but what we have seen in practice is that some entities, in cases that have come before the court, some organizations have made an application first, and then once granted leave, they then make the substantive arguments via amicus briefs. Then there are entities that make the application in one application, and then another submission that is attached to the application, which is called the amicus briefs in substantively made. And I would argue and suggest that it's better to have it together, to have the application itself and also the substantive arguments, because it can also give the court an insight in terms of what it is that you want to bring on board. But so far, the experience, and I've talked to a number of senior legal officers at the registrar's office, is that either of the two has been used, and there hasn't been a problem with that. Next slide. So whether you choose to do the application first, or you choose to do the application plus the amicus briefs, what is important to note is that there has to be an application that is submitted for leave court. And in terms of the practice directives that I've spoken about, or practice directions as they are called, any individual that seeks to make observations or submit amicus briefs, he has to submit a written application, and that written application sets out the reasons why the party wants to make observations, and especially the important aspect, which is what is it, the value addition that the applicant seeks to bring on board. And of course, once that is done, the court can either accept or decline the application. And if it is accepted, you can then submit the substantive amicus briefs. And a question that always comes is, how much time are you given by the court to submit amicus briefs once you have been allowed to do so? And the answer is, there is no specified period. I've spoken about that 90-day period, and it looks like the trend is the 90-day period is given to those that will have had the access via Rule 83 subsection 2 that I've spoken about. And the whole process in terms of time and in terms of whether you can make an amicus brief is within the control of the court. We can move to the next slide, Norma. Then the next point to make is I've already spoken about the fact that there is no specific template. So for all the other processes, the court has templates that it has given. So for example, for the advisory process itself, the request itself, there's a specific template for that. The applications where there's contentious jurisdiction, there are templates for that. There are also templates for where you apply for provisional measures and other processes that you can bring before the court. But for amicus briefs, there is none. And I think it can be viewed positively or negatively. And I think the positive aspect is that it gives you leeway to frame your application in a manner that you think is best so you make your case. But obviously, there's benefits in standardizing this process, and maybe something in future directives that the court is going to do. So there are no specific guidelines on the length, on the page count, on words. I've had a look at a number of submissions that have been made by other entities. I think the shortest application that I saw was 8 pages. I saw an application that was 45 pages, which I think was quite long, but all of those were accepted by the court. The important thing, obviously, is for you to highlight your specific expertise that you want to bring to bear on the matter before the court, and the contributions that you intend to make to the matter. I think you can summarize that in the application for leave. And once that is reviewed, or if you have gone by that route 2 that I've spoken about, where you attach the substantive application, then you in the substantive application, which I'll talk about in a moment, you make all your substantive arguments there. And once it's attached to the application for leave, it can be submitted together. So we can move to the next slide, Norma. And the important thing, obviously, is to ensure that you are quite clear. Your application is referring to which advisory opinion, because the court receives many advisory opinions. So it is important that you highlight the case. So in this case, using as an example, the case that we are talking about, the climate crisis case, we know that it's 001. It's case number 001 of 2025, and it is filed by PALU, and it's in relation to the human rights obligations of states in the context of the climate crisis. So it's quite important that you lay that out maybe in a cover page, and then your submissions can be within that application. We can move to the next slide. I think it's 13. Yeah. So here I just gave a practical example of that cover page. Application for leave to submit an amicus curiae brief in the case of, and I've cited the PALU case relating to the climate crisis change. So you can move to the next. And this is very important. I'll speak about it just as a point of humor, that the majority of cases that have come before the court were submitted by PALU. In fact, the ones which are decided positively, all of them are because they were submitted by PALU. So if you just say the PALU case, it might confuse people. Which PALU case are you talking about? So if you have now done the application for leave, the second side of it, as I've been saying, is the actual amicus brief, which is the meat of your submissions. And again, there are no guidelines in terms of what the amicus brief should look like, how long it should be. But we all know that primarily the headline reason for doing an amicus brief is to provide the court with additional and useful information or perspective that it may not otherwise have access to, often from parties with a strong interest and knowledge in the subject matter. So we can move to the next page. I did scan a number of amicus briefs that have been filed by different parties over the years. since 2011, thereabout, when we had the first case filed, the first advisory opinion case filed. And there are some standard things that should be in your amicus brief. There are variations, but some of these things, it's always good to have a cover page, as I have said. It's neater to have a table of contents. It enables judges to quickly navigate in terms of issues that you raise. If it's a legal case, it's always good to have a table of authorities. But of course, I'm aware that there are other observations that are made that might not necessarily be legal. For example, in this case, we've been talking to colleagues, scientists that want to make submissions. So if there are sources of data, it would be good to have a table of contents that sets out those sources of data that you make reference to. It's important to identify yourself, your interest in the case, and then introduce the summary of the argument that you wish to place before the court. And of course, the statement of the issue and the arguments that you feel that you are bringing on board to the court that will enable the court to make its decision. Then, of course, the conclusion, and of course, you must sign off the amicus brief in as much as you must sign off the application for leave itself as the author of the document that are presented to the court. Let's move on, Norma. Then one of the questions that comes quite often relates to time limits. So, and this is one of the, I would call it a bit of a gray area, right? So in terms of those that are invited by the court itself or Romero Morty, the provision says you must submit within 90 days. And I've already spoken about that, or any other period that is set out by the court itself. Then the question then is, at what point, okay, the first question is, at what point do you apply for leave? And I think once a case has been published, you become aware of it, it's on the website, then you are able to apply. So at that point, we cannot talk of a time frame because you are making your application. So going by the same example, the climate crisis that we are talking about, we know that it became public on 4 September, and the other parties that were directly invited are supposed to do that within 3 months. And so in terms of the time frame, the rules say that they don't say whether that 3 months also applies to these other parties, because we don't know when the court is going to actually say you are accepted as an amicus. So I think it's not clear in terms of whether that 90-day period applies. But what we know as a matter of fact is once you file your application for leave, whether you file it alone or together with amicus brief, the court itself will give directions either in terms of the period within which you must file. You can even seek leave to seek further an extension of that period. You can apply to do that from the court. But the advice that we give parties is that it's advisable to work within the time frame that has been set out for the other parties, which is the 90-day period that we've spoken about. So I think it's not a matter of law, it's not a matter of rule, but just as a practice, it's good to also file your submissions within the 90-day period. So that 3 December date becomes applicable. We can move to the next slide. The recounting of dates, I've already spoken about that. We can move to the next slide. The point is, it's 90 calendar dates, and they are counted consecutively. So I thought it's very important to ground my presentation on precedent. The court is not a court of precedent, but it's always guided by the decisions that it has made in prior cases. And I was just doing a bit of research on the number of advisory opinions that the court has dealt with. You can see on that slide that most of its cases are contentious. Since 2006, it has dealt with 366. And this is correct as at the end of 2024. There are other cases that have been filed. And in terms of advisory opinion, there are 18. And 16 of them that have been dealt with and we can move to the next slide. There are two that are pending. And of course, of those two, one of them, again, both of them have been filed by PALU. There's the death penalty case that was filed on 10 October. Then this climate crisis case that I'm talking about, which was filed on 2 May 2025. The interesting thing is, as we move to the next slide, is advisory opinions are actually very, they are not, they have a very high level of failure. So of those 16, 14, 13 of them have been struck out. And then there's another one by parliamentary, the parliamentary, that PAP, Parliamentary Africa Body, it was also dismissed. The only two that have been successful, and I would invite you to look at these two because those are the ones that also, among other the substantive issues decided on, also deal with the process of advisory opinion. And it's the PALU case, I call it the vagrants case, that dealt with the vagrants laws on the continent, and the other one, which is the that deals with the rights of participation in a government in one's country in the context of a public health emergency. And that case was dealt with during the COVID crisis. So these two are the only cases that have actually been successful and deal with substantive issues. But for our purposes, they also deal with the amicus briefs. And the important things to highlight that come out of this case are the following. We can move to the next slide. So on the vagrants case, what is important to note is that a lot of the amicus briefs were filed on different dates. So there is no specific timeline or a period within which the cases were, the amicus briefs were filed, but each part was filing on its particular day, I think, depending on your own, when you became aware of the case, and of course your internal resources to put together a brief. And I've just highlighted some of the parties that participated there, and I will not delve much into that because I know we've got a colleague from Center for Human Rights who will also give perspective on that. We can move to the next slide. Because we get to the end. So, and we can skip this one. It makes the same point that I made, that there are parties that are invited by court and they tend to have favorite ones, if I can be allowed to use that come back from time to time, and they are all given that 90-day period that I spoke about. And that happened in the vagrants and COVID case. We can move to the next slide. Let's move to the next one. I think because I'm also aware of time. Yeah, this one is important. So this case just gives us the various options or various pathways that can happen once a case has been filed. And I was quite fascinated with the COVID-19 case. So on August 20, the court notified entities that were invited to submit observations. And in January 2021, you can see that that's 5 months later, the court extended the period for states by 45 days. And on the same date, on 28 January, they also invited new entities to make submissions, and that was the Electoral Law and Governance Institute for Africa, COVID-DM, Journal for Africa Law, and International IDA. So those four. So what it just reinforces is the principle that I made earlier on, that the court controls the process subject to its rules. And where the rules are not clear or the practice directions are not clear, the court itself makes that determination. So it's always important to apply to the court to seek direction from the court. And that's what comes out of that court. So you see, and another interesting thing is on 26th of April, the SOAS, Center for Human Rights on behalf of Journal Africa Law, deposited an amicus brief. So from January, that's 4 months later. And we know that in that case, there was an extension that was granted for 7 days. On 28 January, for states, they granted 45 days. And that's one thing that we see with the court, even with the African Commission on Human People's Rights, that they tend to be flexible and they tend to be kinder to the states. They give more leeway to states to make submissions. And I think it's also good because it then enhances the legitimacy of the court before the eyes of the states that ultimately are the ones that are supposed to ensure that human rights are respected. So that's a pattern that you see there in those two cases. And there's a shorter time frame on the SOA as Center for Human Rights case. And it's not to say these are the specific periods that they will apply in this climate crisis case, but just to make the point that number one, you can apply for leave. Number two, the dates that or the period that you are given, it's the court that determines that, subject to that 90-day rule that is specified in the rules. So I thought it was quite important for me to highlight that. I think we skipped another slide somewhere when we're running through them. One that really is the nuts and bolts. How do you submit them? I think it's 19 or 18 thereabouts. But it's really basic things in terms of how do you submit your amicus brief. We have talked about the application, that's the substantive side. You file it before the African court, and the trend now is to use the email. The rules allow you to submit via email, to use registered post, and even to submit physically in Arusha where the court is based. But obviously for expedience, email tends to be the best. And I think you can also do the registered post, but the email is the advantage that it's cheaper and you can also get a response from the court. I see, Norma, you are trying to get to the slide. What I'm going to do is, in the interest of time, I'll just post the addresses, the email addresses. It's slide 15. It's slide 15, Norma. But I'm also going to post it. Yes, thank you so much. So the registry at africancourt.org is the formal email address that you can use to submit the application or subsequent pleadings. The registrar, that is actually the email for the head of the registry. Currently, it's Robert Dr. N. But otherwise, Angela, I see you are back on screen. I'll take that as a cue to stop there. And if there are other issues that arise, we'll address it later on. Thank you so much.
Thank you very much for that insightful presentation. And just a reminder that the Q&A is open. Please do submit your questions. We are answering them as we go. Those that are not answered, we will have some time to answer at the end. I'm going to give over to Brian, and after Brian, Lucian will speak. And I think we have until about 1:15, and then we can leave 15 minutes for questions. Thanks. Over to you, Brian.
Thank you very much, Angela, and thanks again to Comrade Zimbabwe for a very elaborate presentation. Actually, I've been thinking through what more I can add, but maybe to really supplement what he has said already. First of all, by appreciating the opportunity from UWC for this engagement. I've also decided not to switch on my video to avoid similar situations around network connectivity. So yes, for us from the Center for Human Rights, like I was already introduced, we'll be sharing our reflections really from our engagement as Amicus Curiae. Yes, particularly before the African Court, but also to state that we have also done so, and I think much more with the national level and courts. And that is, of course, almost similar to what else we often do in regards to the preparations, and so that's experience that's going to inform my discussion. But maybe to begin, it's a no-brainer really, but to just emphasize it, that the Amicus Curiae, friend of court, as of course we all know, is a very powerful yet delicate tool that is available to us, especially to civil society actors. You know why? Because it enables us to contribute to jurisprudence development and to deepen our the contextual understanding of the court without us being necessarily a party to the cases. So in terms of our institutional experiences, of course, our interventions generally have spanned diverse themes. We have a broad range of coverage of human rights, women's rights, freedom of expression, protection of human rights defenders, now climate, of course, climate justice, climate change issues, and sexual reproductive health rights, etc., etc. And the interventions that we have made have generally, reinforced one key lesson, and that is that an amicus brief is not advocacy by another name, really. It is an exercise in disciplined expertise, right? So we have learned that our credibility depends less on how strongly we feel about the case and more on really how rigorously we ground our contribution in law, evidence, and balanced analysis. So I think now to how we demonstrate our expertise and local standing. Our approach has been, again, threefold majorly. In terms of institutional legitimacy, then subject matter expertise and public interest framing. Speaking to institutional legitimacy, normally we do anchor our applications in the work of the center and its track record. Of course, us being recognized as as expertise, our expertise being recognized at both national and international levels. So we sort of rely on that and also the history we have had in engaging with the human rights mechanisms. So that asserts our institutional legitimacy. So then for actors here who intend to file the amicus brief before the court, again, you have to assert that, why it is you that is perhaps best placed to give that court another perspective, an important contribution that to look and consider in the adjudication of the issues before it. In regards to subject matter expertise, of course, yes, one would expect then that you cite the specific projects that you have engaged on that are relevant for the case before the court. In this case, issues around climate change and its impacts, then also your research outputs. And then if you have litigated before, directly, maybe before the African court itself or before other related bodies, again, it will be important to highlight that we normally, we intend to emphasize in our briefs. Yes, it is important also to clarify that the intention of the applicant for submission of the observation, amicus observation, that the intention you have is to assist the court, right? It's not that you're advancing the interests of any other party. So this balance then reassures the judges that the intervention you're making is capable of enhancing the deliberation rather than a political contribution, perhaps one that is again biased towards your own interest. Of course, it's important to blend doctrinal depth into your into the amicus brief with empirical insight. All right, we find it useful to ground each of our submissions in authoritative sources. The sources of law on the basis of which we claim the rights that we are litigating. Treaties, comparative jurisprudence, general comments of the bodies. And then so we pair those with where we have it, empirical data, and then trends that illustrate the human rights impact of the issues that are before the court. Again, as we do that, maintain the neutral tone. Those are really very, very obvious points. We avoid argumentative language. We are not here as parties, but we are here to not to mirror the parties' submissions, but really to make a contribution to the court, and we try therefore to maintain a neutral tone. Again, it's not a case for advocating for an issue, but you're using evidence to illuminate. For instance, drawing on data from the African, maybe bank or other related institutions that could be useful in terms of facilitating knowledge awareness, but also interventions that are supposed to be enforced by the court's pronouncement through the case before it, to contextualize the human rights implications of the case that is before the court. That helps us to to ensure that there's credibility and persuasion in the submission. I think finally I see that the time I gave myself is fast spent. Yes, very important in terms of the internal review processes. We try to map existing submissions where accessible and engage with the council, where that could be individual or even coalitions that are pursuing the case, and amicus submissions to identify which dimensions they have not yet which dimensions have not yet been focused on. So in that sense, for instance, when I look at, for instance, the amicus before, the case before the court, for instance, we could say, what would the court's, unique contribution to global climate justice jurisprudence, all right? And we try and, say, we look for those angles that have not yet been covered, so that then every contribution, even if there are 5, 10, each one of them is going to be useful to the court. Otherwise, we are wasting time to duplicate efforts. So I think basically that's what I can share for now. Thank you very much.
Thank you so much, Brian. I'm going to give over to Lucian, and you have about, let's say, 7 to 10 minutes, and then we'll head to finish with questions.
Thank you so much, Angela. And yeah, I'll definitely keep to the timeframes because I'm sure a lot of people would love to get into the questions, because I know there will be quite a few just looking at the Q&A folder or question tab. So I'm not going to go and delve into all of the areas that I was meant to, particularly around our experience and our involvement at regional courts, and just essentially go into the thematic areas. And from an advocacy perspective, what we can do and how we can align ourselves so that we support one another in this process. So, as we know, the petition is far-reaching. It is incorporated, I think, over 16 different articles that are connected to rights in one way or the other. Obviously, the paramount one is Article 25, and everything is connected around climate change, climate justice, and what are the obligations of the court. So, the idea of this petition was not to overburden the court. Petitions typically at the African court don't extend into hundreds of pages, but rather is a very succinct piece of paper that's filed before the court on the particular issues we want the court to look at. And then we anticipate that governments, key stakeholders that get identified by the court, and other amicus applicants who come through to bolster and essentially put the rest of the muscle and the tendons and the body together to paint the picture for the court in terms of what they need to look at and what they need to decide. So in terms of that, there's quite a few areas that we, which I think the court would potentially want further information on. I think quite a few people on this call I've had, individual meetings with, and just sort of like painting the same picture, about as long as it's drafted in a way that is useful for the court, they'll most likely accept the petition. And these are some of the ideas that could potentially be useful to the court. So the first one is, of course, the international law integration. We have, of course, got the Paris Agreement, we've got the CBD, we've got the Convention on Desertification, and a plethora of other international laws. We've got the ICJ judgment, we've got the ITLOS judgment, we've got the South American Inter-American Courts advisory opinion as well. And this is all information that I think the court would love to have a look at and to explore and to see how it relates to the African Charter on the particular rights that we've highlighted when it comes to states' obligation on climate change. So, as I said, the Paris Agreement's a really great one. The UNFCCC, you've got the Montreal Global Framework Biodiversity, the United Nations Human Rights Council resolution that came around, right to a healthy environment. There's of course various charters that could potentially be looked at. There's the African Commission as well that has got certain resolutions around climate justice, climate change, and the impact it has on human rights. And it would really be great to have all of that context kind of put before the court in a way that is succinct for them to understand what are the interrelations and what are the connections. The other one is, which could be very interesting, is of course protection of biodiversity and ecosystem integrity. So Africa, as we know, is home to an extraordinary amount of biodiversity, and we know indigenous communities are playing a huge role in environmental stewardship, in protecting those areas, managing them, looking after them. And so this is definitely an area that the courts could definitely lean on when it comes to what are states' obligations in protection or looking after, and when it is connected to vulnerable groups like indigenous communities. One idea that somebody I heard was talking about is, is there a duty to maintain ecological integrity? So those type of questions, that the court can be faced with, would be great to have a look at. Then the other one is around corporate and third-party accountability. So I think everybody I've spoken to knows I have an absolute passion for corporate responsibility and accountability. And the African Charter is one of the few charters in the world that does make reference around monopolies, resources, how they need to be used in a way that supports the communities, that supports the citizens rather than it being destructive. And of course, managing and dealing with large international corporate monopolies and corporations. So this is definitely something that's going to be looked at, and the petition does make reference to this in a number of occasions, but definitely an area that we can look at. So like, for example, what's the state responsibility for corporate conduct in a particular country? That's something that could be quite useful. Due diligence, liability, what are the remedies that could potentially avail to a state when there's violations of rights? So all of that information I think would be quite interesting. Another area as well connected to this, of course, the issue around reparations. Is there obligations around the global north? What are the state obligations on the African continent when it comes to that? The fourth one that's also really important is the transboundary and extraterritorial obligations. So recently in South Africa, there was a judgment that came out that talked about international obligations and transboundary pollution. We know those international environmental principles and the value that the ICJ's played at different judgments that they've handed out between countries. But I think the court would be well versed to look at this and manage this. What does it mean on the African continent? What does it mean in terms of Article 24? What does it mean in terms of future generations? That type of stuff. Does the state have an obligation to warn, etc., and that type of stuff? So that would be quite an interesting one to look at and potentially delve into. Then the fifth one is around protection of environmental defenders. If you read the petition again, this is referenced, but it is certainly an important area. As I said, Africa holds a huge amount of resources that indigenous communities, vulnerable groups are looking after, and they're obviously at the coalface of this impact between government, corporations, and indigenous communities or rural communities and poor and marginalized communities. So again, a very important area in terms of looking at that. How do we bring that information before the court here? I think it would be really important to bring stories and information before the court. That would be really interesting to see and needs to be brought before the court. Then the sixth one is intergenerational equity and rights of future generations. This concept is mentioned, but could be elaborated through evidence showing how current policies and decisions create long-term harms. Youth climate activism in Africa, we could provide examples of how intergenerational rights are being asserted in practice. That would be quite useful, I think, to the court. The seventh one is around implementation and monitoring mechanisms. The request does outline legal obligations, but we don't really talk about institutional mechanisms on how we give effect to that. So it might benefit the court to look at national climate justice commissions, parliamentary oversights, environmental governance, regional monitoring through the African Union or the African Commission. So those are sort of like the ideas that we were thinking about. Look, to be honest, I mean, we could sit here for the next 4 hours deliberating on areas areas that we would like to look at. But these are just some key areas to maybe spark the interest and see if people would like to get involved in maybe developing an amicus. In terms of moving ahead and going forward, I think what's really great is that that there is alignment amongst the justice narrative, the climate justice narrative right now. You've got organizations like the African Climate Platform, the Environmental Lawyers Collective for Africa, Natural Justice, Resilient 40. I mean, there really is a remarkable amount of organizations who are working on this, who are connecting with one another. And if you are interested in connecting with that, you're more than welcome to drop an email to myself or to Norma, and we'll put you in the various networks and see if there's any momentum. Because obviously, this is the first piece, right? Is developing this amicus, but of course, so much more work is needed, national, sub-regional areas to really drive this issue around climate justice and protecting communities and vulnerable groups. And then lastly, maybe the last one is, once the advisory opinion is issued, of course, there'll be this huge push for disseminating its findings and its information. And of course, that will, very much similarly to like the ICJ, need some planning and some strategic analysis to how we bring this advisory opinion before national court. So again, just some ideas throwing out there. But the main idea is to have this collaboration and see where we can take this further as an advocacy piece much later down the road once the court has made a finding. But let me stop there because I know we're running out of time and give really a good opportunity for people to ask their questions.
Thank you so much, Lucian. It was so good to see sort of the procedural aspects from Z to experiences from Brian and then you addressing the themes. There are a few questions in the chat. I'm going to read that and then also give opportunity for anyone here to maybe raise their hand and you can address a question to a specific speaker. So, Lucian, there is a question to you asking if you can identify the decision you referred to in the context, I think, of transboundary pollution. I think it's that case. There's also a question about the role of climate science and input required. And then a question on, will there be any plan to hold a public hearing with the in-person or remote participation of the Amicus Curiae, similar to what took place at the Inter-American Court of Human Rights? So those are the questions for now in the chat.
I can answer the first one super quickly. It's Greenpeace and Natural Justice versus Total Energies. And it was a decision that was handed down, I think, about 3 months ago. If you go to Google, you type in Total Western Cape High Court decision, that will come out and you'll see the issues around transboundary pollution that's mentioned in that judgment.
Right. There's also a question from Stacy asking if you could repeat theme 6 for option 6.
Sure, let me just pull it out here. So it's intergenerational equity and the rights of future generations, and the impact that would have in terms of the various articles that are being violated.
Private.
All
Show
right.
us more. I was like,
Are there questions from anyone else? Perhaps someone that would like to orally ask their question?
There's some questions in the Q&A.
And sorry, I didn't answer the question around climate science and input required. So absolutely around the role of climate science and input, that would be fantastic. So there's a couple of ways you can do it. There can be a submission just on climate science. I know there are people talking about making a submission on just the science, and there's scientists who have actually coming together to potentially make a amicus brief. But if you're going to be undertaking a brief that highlights, the laws, the legal issues, and connecting that to the evidence around the climate science. As we know, the ICJ said, look, the gold standard is the IPCC. If there are other available scientific resources that you then connect and reference that, as one would typically do in any amicus application, please make sure that the sources are referenced correctly, that their information is available to the judges who will be reading that. But certainly we should be putting that type of information in our amicus briefs if one's going to do it.
Right. There is still a question on whether the court allows for oral submissions from amicus at the hearing after the written submissions are filed. And then there's a question of how do we know that the
Sorry,
deadline...
Angela, I've just quickly responded to that. And the short answer is Rule 85. I've just put it on the chat. The court controls that process and makes the determination. And I can tell you out of the 16 cases that I've made reference to, there hasn't been an oral hearing for advisory opinion process.
Great, thank you, Dee. There's a question on how do we know that the deadline for the amicus is 3 December? There is another question from Abadir. We're working on 2 to 3 different topics with at least one that is not strongly related to the two. Are there drives to coordinate so that we can decide whether we want to split up our efforts or collaborate with different people?
Maybe I can answer the question about drives to coordinate. So, so we currently have a working group that's being led by Zee, working on coordination, collaboration and support for people submitting their amicus briefs. If you scroll up a little bit, Nomasango's put a form that you can click on in the chat. We'll repost that again in the chat. And it's a really good way for anyone wanting to get more support, but also connect with others, coordinate across different amicus briefs to please join. We have a monthly meeting and information sharing and a mailing list there. Maybe also to the question about how we've calculated the 3rd of December. The 3rd of December is calculated as 90 calendar days from the date that the court issued its notice for observations. The advice we have from the lawyers involved in the case is that's the best guidance we're going to get from the court on when an amicus brief should be submitted. There is a chance there will be an extension on that, but the strong advice from the lawyers involved is to treat that as the deadline for amicus briefs as well.
Great. There's also questions about NGOs. Is there any leave for a request one has to file to be able to submit an amicus, or can an interested NGO just submit an amicus without having to seek leave from the court?
I think
Okay,
that,
Angela.
sorry.
Okay, go ahead, Dina, it's fine.
Sorry, Tsi. I was going to say for everyone except those who are listed as observers in the court's notice, they will need to submit a request for leave to submit an amicus brief. So that includes NGOs, academic institutions, law firms, anyone else who wants to act as a friend of the court who isn't already identified by the court as one of their friends. And that list was on Zee's slides, which we will share. All others will need to submit a request for leave.
Yeah, clear, Dina.
Right, there seems to be an academic question about of the advisory opinion cases that have failed, were any of these environmental related cases? And if so, is there something we can learn?
Sorry, Angela, do you mind just repeating that? It was breaking up on my end. I don't know if it's breaking up for others.
Okay, it seems to be an academic question from a participant wanting to know if any environmental related cases in the court have failed, and if there's anything we can learn from that.
Zee can correct me on this, but my understanding is that all the applications for advisory opinions that have failed on procedural or technical grounds. So particularly cases that have been brought by parties who were not recognized as parties entitled to bring requests for advisory opinions. That's been the bulk of them.
Yes, that's correct, Dina. And there's not been one that deals with the environmental team, but that's essentially correct. The procedural side, there's one determined on substantive side, but that one dealt with that parliamentary case I was talking about. But you're quite right, Dina.
We have a question for a hand raised from Ayodele.
Yes. Thank you, everyone. Again, thank you to the speakers. I guess that's my cue to go ahead with my question. I wanted to find out if there is any data on the court's disposition to applications of leave to file observations. Is it something that the court is favorable towards? Are they routinely granted, or are they are they denied in most cases? Is there any data out there on that?
I'm very sorry to say, but no.
Yes.
Go ahead.
Okay.
No, if the question, if I had it right, is the court's response to applications for leave, whether they tend to grant or not, they do actually grant them a lot.
Okay.
I've
But
actually not seen any party that has been denied an application for leave.
Okay. Thank you.
Are there any further questions? We still have around 7 minutes for the webinar. All right, there is a question. To what extent has there been engagement with or consideration of findings by other international human rights bodies in the past advisory opinions?
So in terms of using other international that is available, the court does take that into consideration. And so the advisory opinions like the ICJ, I'm sure the African court will be looking at that, just because it is a very good judgment and there's a lot of information there that would be leaned on in terms of exploring. But we must always remember that the main charter that's being used is the African Charter on Human and People's Rights. So anything ancillary to that will be looked at and see if it is applicable or not, and then it would be put in their judgment. But there is a judgment by that was issued against the Ivory Coast. I think it's the Edo case, and in there it's very clear that the African court does and use international law, and it's said so in its judgment that they do so, but it's at their discretion always.
Thank you, Lucian. Are there any other questions? Perhaps any more procedural questions for Dee, or any questions for Brian, who reflected on experiences?
We did have a question earlier that maybe Brian can comment on, which was just about the best way to integrate expert evidence or expert reports into an advisory, into an amicus brief.
Great. So really then, first of all, I think it also depends on how you framed your amicus application itself. But again, this experience, I have to be categorical that I'm not very familiar with the advisory opinions before, in terms of intervention during advisory opinion proceedings. But to say that at the national level, what has happened is that as we are filing the requests for intervention as Amicus Curiae, we also indicate from the very onset that we intend to, among others, have our application supported by an expert, who in that case would be, depending
Thank you. There is a question from Thomas. If there is any recommendation regarding a particular subject or topic that should be focused on in the briefs.
Yeah, so we don't want to try and define too much what the amicus briefs should be and what should look like. There is coordination around it, and as Dina said, there are spreadsheets and groups that are around there talking about what potentially can be looked at. But obviously, we don't want to be closing off any person's opportunity, because there might be something that we haven't even thought about. But I think the ones that I just mentioned in my presentation, I've just put it in the chat now. Those are some really strong areas to look at. And then any other vulnerable group as well. It's not just offenders. There's quite a few of them. That would be my answer. Thanks.
Thank you. I also would have said that. There's a question perhaps just again to Z. Maybe this person missed it in your presentation, Z, but the question is, what is the procedure to ask leave from the court to submit an amicus? And there's also a question, can individuals or organizations from an AU member state that is not signed up to the court request for an amicus?
Yeah, thanks, Angela. Yeah, I think the first one, probably maybe the person joined late because I spent quite a bit of time on it. But the short answer is you filed that application, or the other language that is used is a written request to add to the African court, or an application to seek leave. And I made the point that you simply just have to file it with the registry. The email, we've put it on the chat box. And you must set out the expertise that you bring on board and the issues that you are going to tackle, and the value addition that you are going to bring to the court. And it's up to the court to decide whether to admit you as amicus, and you can take it from there. Then the second question, yes. So this is the beauty of advisory opinion. It's different from the contentious jurisdiction, where you can only file from, if you are an individual or an organization, the country must have ratified the protocol on the protocol establishing the African court. With advisory opinion, even if you are coming from a country that has not ratified the protocol, you can still not only file, ask for an advisory opinion if you meet those jurisdictional requirements that I've talked about, especially the one on African NGOs, and then amicus briefs anyone. In fact, you don't even need to be on the continent to apply to file an amicus briefs. You just have to satisfy those substantive questions that I've talked about, which is, what is it that you are bringing on board?
All right,
Yeah.
thank you. There is a question. Thank you for the presentations. Have I understood correctly that we can also stick to our expertise in relation to one of the 6 topics that Lucian mentioned, and that we do not need to respond or argue in response to all question asks? I think that is exactly what that means. You can select a question as it is aligned to your expertise, but Lucian can clarify.
Maybe it's
No,
worth
absolutely.
emphasizing here that the 6 topics that Lucian mentioned are 6 possible topics that might be explored, but that you can address really any issue related to the application for an advisory opinion that you think is important. So if, for example, it's an issue that Lucian hasn't mentioned or that hasn't been thought of in the application, but that you think is an important issue for the court to consider in its answering of those questions, then you can bring that as well. Maybe that wasn't unclear, but I thought maybe from the question there might have been some confusion there. The court will be answering the questions submitted to it, but and so that is a kind of framework for amicus briefs, but the suggestion of some topics that the court might want to hear more on was just some guidance or a suggestion, so you can really focus on your area of expertise relevant to the topic.
Yeah, I know of organizations who are going to submit a brief, for instance, on rights of nature and how that falls under the protection required for vulnerable groups. So that's not necessarily a question posed to the court, but it's relevant and related. I'm trying to see if there are any other questions. We've actually run out of time.
Yes,
All
Angela,
right.
and for the avoidance of doubt, I think people can engage with the request. It's online on the African Court website, but also we can share it so that they can see the range of issues that are covered there. And just to reiterate that it's not for us to indicate to the parties what you want to file. It's you who is bringing the expertise, and you have to justify that to the court that you have got some value addition, as I keep saying, on this particular theme, and then you apply to the court and then make the amicus brief. Thanks.
Thank you. I also see there's a question in the chat on, do we know which groups are going to speak about certain topics or rights of nature? I think that natural justice is trying to identify which groups are doing what. So maybe I'll let Norma or Dina speak about that. And then we do need to wrap up.
Thanks, Angela. I wouldn't want natural justice to take all of the credit for doing the scoping exercise, but yes, together with a number of other organizations, Lucian and a number of others and myself have been scoping out different organizations that wish to file amicus, who've indicated to us just what their interest area is, and we've been aligning them with other organizations who've got similar interest areas. As Dina and Angela mentioned before, I've been posting a link to a form. If you're interested in filing amicus and would like to know if there's any other organization that has a specific interest in an area that you're also interested in making a submission to the court about, please do put in your details in that form. We host monthly meetings, and we galvanize resources and talk about strategies and next steps in relation to the process, whether amicus or otherwise. So yeah, look for the information in the chat or speak to myself. I'll put my email address in the chat. Thanks, Angela.
Thank you. Thank you, everyone. We have to wrap up. We've gone over time, but thank you so much to our speakers. We wouldn't have been able to provide such an informative presentation and capacity building event without you. So thank you so much, T and Brian and Lucian, and thank you also Norma and Dina. And thank you for everyone for listening and answering questions. As we've said in the beginning, this was recorded. We will just give us a few days to edit the recording slightly, and we will upload it to our YouTube channel. We can also send an email to everyone with the slides if you want to use C slides, of course, with his permission. But thank you very much. And we really hope that this can help everyone put together great briefs and that we can get a strong advisory opinion from the court. Thank you and have a good day.
Thank you, Angela, as well.
Big
for
thanks
hosting.
to Angela and Landry as well.
Thank you.
Thank you.
Thank you.
Thank you, everyone.
Thanks, everyone. Have a lovely day.
Thank you, everyone. It was a wonderful webinar. Bye.